Welcome to On the Story. It's Thursday, April 17th. I'm Bobby Batista.
And I'm Bill Nygett. It was a law that was meant to change things for the better for America's black citizens, the Civil Rights Act of 1964.
Here's a clip from 50 years ago as then-President Lyndon Baines Johnson signed it into federal law.
Its purpose is not to punish. Its purpose is not to divide, but to end divisions. Divisions which have lasted all too long. Its purpose is national, not regional. This Civil Rights Act is a challenge to all of us to go to work in our communities and our states, in our homes and in our hearts, to eliminate the last vestiges of injustice in our beloved country.
The Civil Rights Act, which had the longest filibuster in U.S. Senate history, wasn't just intended to help black Americans. It was meant to benefit all minorities. But 50 years later, why are an astounding majority of racial discrimination lawsuits dismissed in Georgia?
Joining us tonight to talk about the Civil Rights Act and that disconnect, Amanda Farahany. She's an Atlanta attorney who authored a study that points out this significant problem. And Chad Schultz, who offers the other perspective. He's an attorney who represents the businesses targeted in this kind of lawsuit. Welcome
to both of you. Amanda, you maintain that over the last 50 years, the courts have stripped people of their civil right to a jury trial in a workplace discrimination case. What's going on, and how did you discover that?
Well, we for years have been looking at what was going on, in particular in the Atlanta court system where we practice. And what we had seen is that the cases were starting to be dismissed at a pretty rapid rate. So I started off thinking, well, what am I doing wrong when my cases started getting dismissed? And I started to look to see what's happening, and we started to analyze what the courts were doing at what's called summary judgment. And what we found was that in almost 95% of the cases, the court was dismissing the case.
Okay, let's break this down a little bit, and I think we've got a full screen here that we can pop up some of these percentages, but 81% of discrimination cases were dismissed in full?
Correct. So 81% of the time, any kind of discrimination case that was brought was dismissed by the court. And what that means is that the court determined on its own that this was a case that a jury could never find in favor of the plaintiff.
And you have a comparison here to other states, we should point out.
Yeah, so one of the things that we heard in response to the Northern District of Georgia, the Atlanta court system, was that the law in this area is bad. And so what we did is we looked at a sister state that has no state laws just like ours. And what we found is that in Alabama, they're not dismissing cases at the same rate. So
let me jump in if I could. And by the way, I apologize. We will say Amanda Farahany.
That's perfect.
I apologize for that incorrect pronunciation. I want to make sure I understand that these suits are being dismissed because the courts have determined there's not enough evidence to bring the case before a jury, correct?
Yes. So what the courts say is that based on the plaintiff's very best case, what they're saying happened, that no reasonable jury could find discrimination. And these are cases where the N-word's used on multiple occasions. I mean, really egregious acts are happening.
Okay.
All right. I think we need to bring Chad in here because you maintain that Amanda's study is flawed or controversial in some way. So how so?
This is how. If you look at the number of cases that are filed in Georgia on discrimination on an annual basis, it's about 500 cases. If you look at the study and you look at the cases that are dismissed on summary judgment, those are only the cases that have not been resolved by the parties. They're only the cases that the employer feels so strongly that there's no merit to, that they go all the way through the process, spending lots of money. And those companies that go that far to where they actually file a motion for summary judgment and the court actually makes a ruling on it, those are only the cases that the companies really believe there's no merit. So those are the ones that they've gone to the expense and the trouble of going that far and not settling. The vast majority of discrimination cases get resolved at some point through the process. So these are the outliers. These are the ones that companies believe they need to stand up for. And statistically, Georgia isn't really any different than any of the other states. And there are very few of these cases that ever go to trial regardless. I mean, in any state, there's only about...
Doesn't that put the plaintiff in kind of a tough position, though? If, I mean, the company clearly has a lot deeper pockets than the plaintiff generally, and the plaintiff has to work for a living, and, I mean, does it put them at a disadvantage?
It really, I don't believe, puts them at a disadvantage because, as I say, the vast majority of cases do get settled. Think about this, 5,000 EEOC charges get filed a year in Georgia. And the EEOC, is the federal arm of the government that's there to investigate those charges, they only find 3.7% of those have merit.
Here we go. We just pulled up your statistics here.
Exactly.
So, but on the basis, let's follow up on this, what you've presented here, Chad. You're saying that only fewer than 8.5% of the cases settle, right?
No, I'm saying that that's at the EEOC level.
Okay.
Then you go to the lawsuit level.
Okay.
And at the lawsuit level, 90-some% probably settle. Some do get dismissed, but...
Let's back up. Could we please back up for my sake?
Sure.
Maybe our viewers need to understand, what are we talking about when we talk about racial discrimination? What do these cases look like? What's happening in the workplace that you're worried about and that you have to defend the company against?
So things are happening in the workplace where employees are being told that they're being fired because of their race. There are things where they're having the N-word used on a multiple basis. I mean, the courts have repeatedly said using it, up to 10 times in a few-month period is okay, and we allow that in the workplace. Or, using derogatory terms like monkey and things like that. And the courts say that that's not illegal.
Okay, so I'm just guessing here, but this has got to, when it's something like that, it boils down to he said, she said for the most part. When it gets so, where is any recourse for a plaintiff?
In those cases, the court, in my opinion and my experience, they don't dismiss those cases. For example, 2 weeks ago, I had a jury trial where there was evidence like that. Mm-hmm. The company said, look, we were never aware of it. We don't think it happened, but if it did, we weren't told. And that case went to a jury. It was a 3-day jury trial. And so in cases where there is the light was red or the light was green, a swearing contest, courts don't grant summary judgment.
It's simply not true. That's not what the cases and the orders are showing. So Chad's case was the one case where a litigant actually was able to get by, and what they had in that case was 150 times that the N-word was used in a 1.5-year period. That's what the court is saying you've got to get to before we're allowing to get through. All the other cases, every single racial harassment case in 2011 and 2012 was dismissed, 100%. And in those cases, there's multiple usage.
Where's the bar for that?
Well,
where was the bar?
In my case, there was a swearing contest, and ultimately the jury concluded they found for the defense.
I applaud. They got a jury trial on that case, and that's what it should be. A jury should be making a decision about what's okay in society, what it is that should and should not happen, not a judge.
So, Amanda, let me make sure I understand this. You say that the courts have said in the past that you can use racially derogatory terms 10, 15, 20 times, and it's not illegal.
It's not illegal.
So what's behind all this? Are you suggesting that the courts are biased in the way they interpret the law on these things?
I think that the numbers show that there's a problem. I don't know what's going on in the judge's mind, but what I know is that our system was set up so that juries could make this decision instead of an individual. And what we have are judges that are appointed for life that are making the decisions that the jury should make. They can't evaluate the he said, she said at this stage because they've got to decide what is the plaintiff's best case and believe it. And based on what he or she says in that one, then only in that set of circumstances does it get passed.
All right. If that's so, how often does it happen? Someone comes to you to be represented, and they tell you that one of my supervisors has used the N-word 10 times in the last year in describing me to fellow workers.
Right.
At that moment, you take that case.
Probably not.
You wouldn't take that case because the courts have, you've just, but so then, okay, so you won't take that case.
Right.
But you, representing corporations, I would think that that may not be something you could get through in court, but this is something that would call for a settlement, wouldn't it, outside of court in some cases? You don't want individuals to not have a chance to settle with a company, even if the courts won't take it.
No, but what happens is when we go and try and settle with the company's lawyer is going to
Take us
say,
to court.
yeah, well,
Okay.
you're going to lose this, so why should we pay what the value of what happened to this individual is? So even when there's settlements, these settlements are in the shadow of these dismissal rates, and so the cases aren't even resolving for really what the harm is.
That has not been my experience. My experience has been that those kinds of cases are very rare. Those are the
what kind of cases?
One where there's
rare?
direct evidence of discriminatory animus, or where there's direct evidence of somebody using an inappropriate term. Those are very unusual cases. And there are so many opportunities for a company to settle a case long before it gets to the phase that we're talking about today. And those are really the cases that are very unusual. And you talked about the judges. Are the judges biased? The judges here, there's 16 judges. The majority of those judges have been appointed by Democratic presidents. They're very diverse.
But Amanda, you also claim that judges are being trained to get rid of civil rights cases.
So Judge Nancy Gertner, who is a former federal judge in Boston, went to what they call baby judge training. And while they were in that training, she was actually taught, here's how you get rid of civil rights cases, and went through a litany of, here's the 10 ways to look through to get rid of it.
Is that because, are we that knee deep in cases, or are there that many frivolous cases that they feel like they need to do that?
I don't believe they're doing that. And if you look at the system that we have in Georgia, you actually get, as a plaintiff, you actually get 2 judges to look at your case. First, a magistrate judge who makes an opinion. Then you can file something with the district judge saying how you disagree with that. But the other thing is, it's not like at the end of the day, a district judge can just do whatever they want. It goes then to a court of appeals, and an appeals judge determines whether the judge made a legal decision.
Amanda, you were shaking your head through a lot of that.
Yeah.
It's a long process.
So that's a problem. So only in these discrimination cases are the plaintiffs required to go through this 2-judge process, which increases the amount of time and the burden. And what we're seeing is that if a magistrate judge recommends that the case be dismissed, 100% of the time the judges are following that recommendation. But if they recommend that it not be dismissed, 25% of the time they're overturning it and throwing the case out.
Okay, so we're not in court. We're talking casually. Would you both stipulate that there is probably some form of racism taking place in many corporations, many companies across the country?
What I would say to that is that there are lots of situations where people feel they've been treated unfairly, but it does not rise to the level of being illegal, and is probably not because of the reason that they believe it. But I don't believe that corporations today are making decisions based on race and sex and illegal characteristics.
I absolutely disagree. And you know, Chad oftentimes sees the worst of the cases because he's right. A lot of cases do settle, and a lot of times they settle before they get to an outside lawyer. We're dealing directly with the company. But a lot of cases don't settle. And we're talking to over 100 people a week, and the things that we are hearing today are not at all what you would imagine. I mean, a case we just took where they came in with a new manager, fired every African American and Hispanic, and replaced them with all white people.
Wow, this is an issue clearly we need to keep an eye on and keep the debate going. Thank you both very much for coming in.